Hello, my name is Dillan Savage of Wirth Law Office, and I practice primarily in the Oklahoma City, Oklahoma area. Today we are going to be discussing Inconvenient Forum as an issue regarding custody proceedings. So as you can imagine, Inconvenient Forum simply means that is inconvenient for someone, whether or not it's the court, the parties, or otherwise, for the custody proceeding to occur within the state of Oklahoma. So, when a custody proceeding has been initialized, the court itself in Oklahoma can just deny the jurisdiction over the case because they find that the forum being in Oklahoma would be inconvenient for the parties and it should not occur here. Now, if the case has already been filed, the court can file its own motion regarding the inconvenience of the forum. The parties can file a motion, or a court outside of Oklahoma can file this motion. So, what are some things that are considered when looking at this? Now, just so you can see this yourself, I'm going to tell you the statute. It's Title 43, Section 551-207, entitled Inconvenient Forum. Now, I'm going to read over Section B, what they look at. So whether domestic violence has occurred and is likely to continue in the future, and which state would best protect the minor children and or party that is the target of that domestic violence. The state is going to look at the length of time the child or children has resided in the state of Oklahoma and also outside of the state of Oklahoma, the distance between the court in this state of Oklahoma and the court in the state that would assume jurisdiction over the case, the relative financial circumstance of the parties, any agreement of the parties over jurisdiction of which state should have that jurisdiction, the nature and location of evidence required to resolve any litigation that's ongoing, any custody proceedings, the ability of each court and each state to decide the issues quickly, because the court of Oklahoma and any court really is not going to want your custody proceedings going longer than necessary. And then the familiarity of the court of each state with the facts and issues in the pending litigation. Now, if the court determines that it is best to let the other state deal with the matter of child custody, but they're still willing to move forward with the issues of a divorce, for example, the court can actually set aside the child custody proceedings and still continue forward with jurisdiction over the divorce proceedings. It's quite interesting, really. The court as well can say that, hey, you need to move this over to the other state in its entirety. And at that point, the state of Oklahoma doesn't necessarily have to immediately terminate the case. They can put it on hold, they can pause it, and once they've determined that the case has moved to the proper jurisdiction in the proper state, then the case in Oklahoma will be terminated. If you found this information to be helpful or you believe it could help someone else, please go to theoklahomacityattorney.com. My name is Dillan Savage, and thank you for watching.